It's now 12:04. We'll wait another couple of minutes. We're here on the case of Antar versus Wachter. That is docket number 23-502-4049. We're scheduled today for a hearing. Oh, something just came in. Reply to defendant's objection. Can I see this?
Yes, it should load up.
There's two of them. How come I have two of them?
Oh, you're right. You should just file this today.
Well, we have late papers being filed in this just this morning.
So those, Your Honor, if I may, this is Mario Cerami.
Yes.
PRAME. So there was a motion for sanctions.
Yes.
And Attorney Wachter and I filed late on Friday our objection to the motion for sanctions. In the happenstance, if it should happen that the court was inclined to rule, we just went real quick and filed motions opposing the sanctions.
There's a reply to yours.
Oh, there's already a reply?
That's what I just was telling you.
I'm sorry, Your Honor. I have not seen that. That is news.
We haven't seen that.
That was filed at what time, Mitchell?
That was very recent. That was probably like an hour ago. So,
Very well.
we understand why you wouldn't have seen it yet.
All right, have a seat.
I don't know that it's going to change anything.
Does counsel know what law school? Does counsel know if Ms. Antar is in law school?
She is, to the best of our knowledge, she is. Whether or not she is this semester, I don't know.
Do you know which one?
UConn.
We actually have there's a filing in another collateral issue case where that's noted by the court.
UConn.
It's UConn. It was ostensibly as of October 23.
I was just wondering if wherever it was, they were teaching the local rules, the Connecticut rules of civil procedure. All right.
Yes.
If you don't know how to navigate a courthouse, it can be
Federal court, and they're also intended to be adopted by the states if they want to. It was never meant to supplement the state.
And they are
recently before the deposition filed the federal lawsuit for saying
Yes. There are big differences I've noticed.
alleging fraud. Like, you know,
New York
proof causation. Saying it's because of fraud isn't really helping, is it?
Okay.
But one marshal said they did see her earlier. I don't know where she is.
I don't care about
Yeah, I'm just letting you know.
the New York rules of civil procedure are like as big as this room, and they test on the bar exam, New York bar exam, for everything in there, like how many days for this, how many days for that, which is never at the Connecticut bar. We go on what the subject matter is. They go on everything.
The UB, it's all uniform. The UB is based on the federal rules of civil procedure. So they no longer do it, maybe New York, but most don't do it by state anymore.
I didn't find her. I checked in the back.
All right, marshals. We have marshals here. Has anybody seen the plaintiff, Theodora Antar?
I have not, Your Honor.
Have you both looked the second floor and the first floor?
I checked the whole first floor and second floor, Your Honor.
Perfect. Thank you, Marshal. All right, so we're here, and it is now 10 after 12. This case was scheduled for 12 o'clock, and there was a motion for fees by the plaintiff And the court has reviewed the documents in addition to the fact that the plaintiff is not here. The court has reviewed the Yes? Aha. Almost.
Oh, she's here, Your Honor.
Almost. Suggestion. Someday, remember to be on time. It would have been terrible if I had ruled on this because you weren't here. And I don't like to do that. Okay? Okay, your name, please?
Theodora Antar?
You're representing yourself in this matter?
Yes.
All right. Counsel want to identify themselves for the record?
Sure, on behalf of the defendant, Mark Wachter, I'm Kenneth Votri, V as in Victor, O-T-R-E.
All right.
For defendant Ashley Gray, this is Mario Saran.
All right.
Noel Bush and Lewis.
Very good. So I've read all your papers, including the reply that you filed this morning. All right? Is there anything else you'd like to tell me?
I just wanted to say that from reading both of the motions to dismiss that the defendants filed, I understood there was only the issue where they stated that the summons was not signed by the clerk of court, and the summons was amended and signed by one of the clerks here in Milford, and the amended summons and amended complaint was served on both defendants.
That's not the issue here. The issue here is whether or not the court should grant attorney's fees and sanctions, and whether or not the rules in Connecticut provide for that. You have cited federal rules. I've cited a U.S. Supreme Court. You have not cited any case in Connecticut or any rule in Connecticut that allows the court at this point in these proceedings to award attorney's fees.
Well, the court stated that today's hearing was set to hear the two motions to dismiss. And so I objected to that. I filed the motion for sanctions after attempting to mark off this hearing.
Wait a minute. So maybe I'm confused. The only thing I have down for me for today is the motions for sanctions. Am I not correct?
Counsel?
Counsel?
No, Your Honor, I think the motion to dismiss this was the date set for the motion to dismiss. You filed your motion for sanctions in response to those motions, I believe.
So the motion to dismiss was down for today?
Yes, Your Honor.
Okay, let me...
It had been continued, Your Honor, because I was on trial, if you recall.
All right, well, so give me a second, please. And I apologize for an error that I had the schedule wrong.
I think the continuance is entry 126, Your Honor.
Excuse me?
The continuance was entry 126.
And that is the continuance that it be today.
Yes.
Have a seat, gentlemen. I remember, I did read this before. All right. Now I did read it before. I'm glad you brought it back to my attention, and I was under the impression as to what exactly was here for today. All right, Ms. Antar, what are you telling me? Why shouldn't this be dismissed when the complaint was not properly served?
Your Honor, the complaint was properly served and there's a return of service on file with the amended summons and the amended complaint.
Well, where do you have a right to do an amended summons and complaint?
Well, first of all, the defendants stated in their memorandum of law that that was a requirement. I then spoke with the court clerk who initially, it's the clerk's obligation to sign the summons. The clerk stated she would sign it, yet she failed to do so.
Well, so...
I then had it amended.
She may have failed it from your point of view. She may have failed to do so, but then you took it and had it served without a signature from the clerk. So the defendant received, if I'm correct, what you're telling me, is copies of the papers, the original papers, with no signed summons. Right?
Correct. Then they both filed an appearance and they filed their motion to dismiss on the grounds of the unsigned summons. I then rectified the situation by getting it an amended complaint, an amended summons, which was properly served on both defendants after the fact.
But where does it say you have a right to do that after the original? Why didn't you have to start all over again?
I actually cited in my motion in my the practice book that does give that right, and so it states that.
Where's my practice book?
I can just have a second to pull up my filing.
When you want the paper?
Yeah.
And Your Honor, if I may also, from the Attorney Vautray states in his motion that in order to remedy this defect, the plaintiff must reserve the defendant with a non-defective signed summons as required by the Connecticut General Statutes. Until defendant is served with summons containing signature of the Commissioner of Superior Court or Assistant Clerk, court lacks personal jurisdiction. That was filed on November 21st, and the amended summons and amended complaint were served in January. So that's why I'm saying the issue is moot, because per general statutes, off the top of my head, I don't have the number memorized. I could refer to my motion if I'm able to pull it up on my tablet. However, I did everything procedurally that I was to do to amend the summons, and I tried to do everything that I was able to do to get it.
You have a statute that says you can amend the summons after you serve it without one?
May I pull up my...
Yeah, sure.
Okay.
Take your time. Have a seat. Attorney Vautray, did you send her a pleading that says all she has to do is send a amended complaint with a signed summons?
No, Your Honor. I said in order for it to be a lawsuit that has to be responded to, she has to serve and return a signed summons and complaint. I said nothing about her amendment rights. The problem she has, and I've been doing this so long, Your Honor. First of all, she can't amend her complaint and summons without the permission of the court, except within 30 days of the return date. So we're beyond 30 days of the return date. Plus, I'm not even sure that's the case, because the original action that was filed doesn't exist. If without a signature on the summons and complaint, nobody was summoned into court.
Let me ask you something.
She would have to start again.
Yeah, Ms. Antar.
Yes.
I've been at this a few years. I don't understand. Why don't you take the simple step of starting again? Then you don't have to be here.
I did all of the steps that I'm required to do
No, you didn't
by
answer
law.
my question. You wouldn't have to be here today, and you wouldn't have to possibly be involved in appeal if you took that piece of paper and started again with a signed summons. Why wouldn't you do that?
Your Honor, by law, an amended complaint and an amended summons replaces the original complaint and summons.
So you're
and I
not
can refer
listening.
to the statute that I was attempting
You're
to pull up
not
if you give me a second.
listening, please.
You said I'm not doing the simple thing I was supposed to do, but I did.
Well, unless you lose today.
Well, may I have the opportunity to pull up my motion?
Yes,
Okay.
please.
Thank you.
And by the same token, counsel, why, if this case is going to eventually go forward, why don't you proceed now?
Well, the reason is, Your Honor, and frankly, I'm not conceding the point that if we end up with a verdict and I'm up on appeal, I'm going to raise that issue. So you asked, let me put it this way, Your Honor, for a long, long time, I taught a course called International Civil Litigation in U.S. Courts. And I would teach my students, if you have a problem with the service or jurisdiction of your complaint, just start over. Don't come and try to save the day because you're going to lose. And the problem is she had no lawsuit to amend because it wasn't signed. She then served something new and plopped it into this file. So the court never had either personal or subject matter jurisdiction over the original case. 2, she can't amend without permission to amend unless it's a correction done within the return date period. So what she's trying to do is start a new lawsuit, but not start a new lawsuit. All she has to do is serve a complaint, return it to court. I acknowledge she will have to pay a return fee. It will be a lawsuit. You can't amend and create a lawsuit out of a lawsuit.
Objection. Objection, Your Honor. I have a law that states that that's not accurate.
No. You sit down. We only talk one at a time. This is not kindergarten where people just stand up, raise their hand, and talk. This is not how we do it. I will, when he is done, I will tell you, I will call on you. Is that okay? That's the way that's the way you do it.
An amendment as of right has to be done within 30 days of the return date. We've all done it. You can correct the summons. But you can't correct it beyond the 30 days unless you get the court's permission to do so. She hasn't done any of that. So right now, the complaint should be dismissed. It's also, honestly, not to give her advice, it's actually the right thing to do to protect yourself. But that being the case, there isn't, and we're not agreeing to allow, and I'm not waiving any objections I have to allow any deviation from the...
Okay. Now, yes.
Your Honor, I just want to know if you had an opportunity to review the motion that I filed, entry number 131, which was the objection to Defendant Wachter's motion for continuance.
Hold on one second. Why am I dealing with a continuance issue?
So, Defendant Wachter's counsel had filed a motion for extension of time, saying that he wants to extend the timeline to file any special motions to dismiss pursuant to statute 52-196AC, requesting 30 days from resolution of the motions to dismiss. And he cites entries 102, 103, 109, 110, 116, 128. And he's saying that the amended complaint return of service was filed on January 11th with the return date of January 23rd. Saying that he would need to file his motion by February 22nd. And he's saying there's pending motions to dismiss. So he's acknowledging the fact that the return date was changed with this amended thing. And
none of that has anything to do with what we're doing today.
So if I may, I actually did speak to the court. The clerk's office instructed me that the process is that they will, since it's their error, where they refused to sign the summons initially, by law they were required to do so. They did not do so. They said to me, if you want to have it reserved, you need to come in and have us re-sign the summons. I then did that.
I am not bound by what some clerk told you downstairs. Not at all. They don't make the rules.
I even had a fee waiver, which was granted by the court, to pay for the service to have the amended summons served.
They don't make the rules.
I'm not insinuating that they do make the rules, but I was trying to cite that in my objection to defendant Wachter's motion for a 30-day extension of time, which in my opinion is an attempt to further delay the proceedings. I mention and I cite several laws which include the fact that it states here on Exhibit 5 of my motion, my objection to his motion, cites Section 52-72 of Amendment of Process. Any court shall allow a proper amendment to civil process which has been made returnable to the wrong return date or is for any other reason defective upon payment of costs taxable, and it states the amended process shall be served in the same manner as other civil process, and it says if the court finds parties had notice of dependency of the action, their rights have not been prejudiced or affected by reason of defect, any attachment made by original service and rights under lease pendant shall be preserved, continued from the date of service original process as though original process had been in proper form. And so I included that there in a small procedural defect that it's not my fault. If I have the ability to sign it myself, I would have. It states that a pro se has to hand it to the clerk. She stated she would do it, and it's all documented that she then failed to do so. I then took steps to amend it, and I was told by the court that this is the process, and from the statute, it states the same thing in terms of amendment of process.
I don't agree.
I'm sorry?
I don't agree.
On what grounds?
Excuse me. I don't agree because there was never a case started in this court. You can't amend something that didn't exist. You have to start anew.
Which is why I amended my complaint.
There was no complaint because there was no lawsuit.
So the amended complaint acts as the official complaint then? How does it not?
Do you have anything else you'd like to tell me?
I'd like to say that neither of them are objected in their motion to dismiss. The only thing they talk about is the fact that the summons was not signed. The summons was then signed and properly served according to the statute. I cited the statutes on amendment of process.
The court disagrees.
But you're not explaining why you disagree.
No, the court disagrees because there was no lawsuit to amend.
Okay, so Attorney Vautrer states in here that I must reserve defendant Wachter with a non-defective signed summons as required by the Connecticut General Statutes.
You have to start again with a lawsuit, with a complaint, with a proper service signed by a lawyer or somebody authorized by statute. Once that is signed, served, and returned to court, the case exists. As of now, the case does not exist. Anything else you want to say, counsel?
No, Your Honor.
Counsel?
No, Your Honor.
All right. For those reasons, the motion is denied. I'm sorry. The
dismissal is
the
granted.
motion to dismiss is granted.
Thank you.
Thank you.
Thank you, Your Honor.
And if you'd like a copy for that, you can go down to the court reporter, monitor's office, and you can order yourself a copy if you'd like to appeal. If you'd like to just start anew and not have this headache, you can do that also. Okay?
And I just want to put on the record my notice of intention to appeal.
Good. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, ma'am.
Good to see you.